New ban-in-the-box laws just keep coming, and GoodHire wants to make sure you're up to speed on your obligations under these laws. In this short video, I'll walk you through a few steps to help you determine what your obligations are as an employer under ban-in-the-box laws. So let's get started. It sounds simple, but the first step is determining if a ban-in-the-box law even applies to you. So check to see if you or your prospective employees are in a ban-in-the-box jurisdiction. You can use GoodHire's state law chart for this. If there's a law in one of those locations, you'll need to find out if you meet the definition of an employer under the law, and that's usually based on the number of employees you have. Then you'll have to determine if your candidate meets the definition of employee. If you and your candidate meet those definitions, you're going to have to follow the provisions of the ban-in-the-box law for that candidate. This means you'll need to turn to the second area of focus, the timing of the background check. Most ban-in-the-box laws prohibit you from running a check prior to a conditional offer or a first interview, so check the timing provisions of the law. Next, see if the law restricts what kinds of criminal records you can consider in your hiring decision. Some ban-in-the-box laws prohibit the consideration of non-convictions or records older than 7 years. Now we come to adverse action. Some ban-in-the-box laws require that a pre-adverse action notice include a little extra documentation or a specification of the exact criminal record that could lead to adverse action. You may also be required to use a specific form, and that's the case for employers that are in New York City and Los Angeles. So make sure you're working with your screener to ensure that your pre-adverse action notices are compliant. There may also be special adverse action waiting periods that apply. Federal law requires an employer wait 5 business days in between sending a pre-adverse action notice and a final adverse action notice. But some ban-in-the-box laws require longer waiting periods between those two steps, so work with your screener to make sure that the correct waiting period is followed. Finally, make sure you're performing an individualized assessment if required under the law. When you're ready to send your final adverse action notice, make sure you include any specific language that's required under the ban-in-the-box law. By following this framework, you're more likely to be in full compliance with ban-in-the-box laws. To follow these steps online, just click the link to get GoodHire's easy-to-follow guide.